If you want to continue the marathon tomorrow, at 6:30, Hayford High School cafeteria.
It's on my way home.
I think, would you mind not filming from right here, because we have our conference computers?
Oh, school board.
That would be great, thank you.
But he thinks there's 317 students in his.
It's not public comment, right?
There will be public comments, but yeah, you might want to move farther back if you want to capture public comment.
Take the mask off.
Thank you, thank you for
The
that.
other people.
Oh, no, would you not let me do it on my shoulder?
Right, you're back. I think so. Somehow you're not human.
All the whole family?
Are you excited?
Her deal were.
But kids are involved.
No, they lifted it back. Like the school board.
Yeah, but this is also state.
That's why my kids are now. Things got so stupid with that transparency. My kids are.
No, it's fine. We'll leave it on now that I'm actually.
I'm not doing that.
Yeah. I'll yell at her when she's doing my phone. Yeah. I just wanted to give you a heads up. And unfortunately, we're going to take care of
But I think just takes one person.
COVID
And
message
there's
went out
one case left.
last week.
And then there's more than one.
Oh, is it working? So I actually had to like stop some stuff down. So we'll just share. So usually probably when you're talking and I'm trying to be very different from. Unless you want to give my report. No, I'm okay, thank you. How about you?
Then you just file bankruptcy.
I have one.
It's the kids, that's why.
Okay, we're not talking about that. We're talking about.
We should have a county mandate this.
Well, that's going to be, we'll wait till the next meeting.
The microphone got rid of Never mind. Yeah. Okay.
I would still actually leave it.
Okay, we're gonna go left.
Is Jeremy here?
Yes, he's on.
Good.
All right, Jeremy, are you ready?
Yep, I am ready.
Perfect.
Is everybody ready there?
Yes, sir.
All right. We are back with County Matters, Planning and Zoning, item 5.1, receive an update, discuss, and provide direction to staff regarding the commercial cannabis cultivation program. No fiscal impact.
So I'll go ahead and get started then. Thank you, Chair Brown. I'm going to just kind of do a quick overview of where the county is as far as what we're doing with some of the licensing, and then I'm going to turn it over to the people who actually do the heavy lifting. We'll have Kim and David involved. But where we are right now is with the lawsuit that we were involved in, and the court order is we are now required to, for every license, to have a each sequel compliant. So what we've done is we've gone out and we've secured 2 additional consultants. We already have SHN on board, and we just extended their contract. And to that, we've added to the team Helix and is it Laco? How do you pronounce it? Laco or Laco? Laco. Both very experienced engineering, planning, and cannabis organizations that are going to do nothing but help us through the licensing process of screening to our Appendix C reviews. Met with them a couple different times. They're in contract as we speak. I'll start reviewing applications next week. But when I spoke with them, one of my specific questions was, as we interviewed them, is told them we have 307 approved applications. These are applications that we know are in good standing, have everything in, and they are ready to start reviewing their Appendix C. Does that number intimidate you? They said, absolutely not. I said, okay, if I throw the date December 31st in, does that change your answer? They said, absolutely not. So we are going to give them all 307, and they will start reviewing the applications process, and we're going to start accepting Appendix C paperwork. What do we say, Monday, Kim?
Appendix C documents for the 307.
307, yes.
Yeah, just specifically 307 on Monday, yes.
So our goal is to, we've been given direction to do what it takes to get these applications licensed up. So we immediately reached out. We've got the 3 consultants on board. Our issues we had before was staffing. We just didn't have the manpower to complete what needed to be done in the amount of time needed to be done. I believe firmly we have the consultants on board that are going to be able to do that heavy lifting for us and get through the application process and start issuing license much sooner than we anticipated. We're also, because the lawsuit removes the moratorium on accepting new licenses, we're accepting new license too. We no longer have a moratorium on issuing new license. So I'm very optimistic the direction we're going. Yes, there's going to be some issues here and there, but the team we have to work through this, I believe, is going to be able to do it very, very quickly. And I know that there's issues with multiple seasons, but the deadline of March 30th, getting our license out, is a target that I feel is easily achievable to get as many licenses as applications turned in with that are complete. So with that, if there's any questions, I'd be happy to answer that. I'm going to turn it over to, I believe, David, and he's going to start going through some of the timelines.
Yeah, so my role here, I was hoping to do 2 things. One was to walk through the timeline of the TAA lawsuit and some description of the court order itself. To do that, I'd highlight one thing is that no, I'm not a lawyer, so I am going to breeze through it, I guess, without the legalese, I suppose. And that is just so that we can all essentially be on the same page in terms of any potential discussion about any particular detail of the timeline or the court order itself. Excuse me. So to that end, I'd be happy to answer any questions either during or after this particular section of the update, and then hand it over to Cam after that point. So I know that much of the room here is already very familiar with it. I know the supervisors, of course, have been updated about the progression of the timeline or the court case itself, but perhaps some of the public is not aware of it. So to start with, it's...
David, I'm sorry, I'm having a little hard time with your mask.
Okay, just appropriate following the rules. That sounds better to me too. Okay. So in January of 2019, TA first filed suit against the county, basically with 3 complaints. One is that CEQA was not being followed by the program, that it was not transparent, and that there wasn't enough public notification of license status or licenses that were being issued. So during that time and up until August of 2019, the county was attempting to respond to that and develop its program as it was anyway. But this sort of changed the playing field in terms of some of the dynamics of the program. During that time, of course, we were in the process of developing our EIR, which was going to address the CEQA component, which was the principal component in the complaint or in the petition. That being said, August of 2019, the county entered into a settlement agreement with TAA, and some components of that settlement agreement were that CEQA would be complied with, that there would be notification of licensing in a certain way, and that the public records request, which was really following the state or state law, public records request would be adhered to. The county responded to all of that. Again, we were in development with the EIR, which was to meet CEQA requirements. The program streamlined its public records request format in terms of templates, working with TAA, and we had continued at that point to publicly notify neighbors or in the paper if a license was issued. Part of that settlement that again was put before the court was for essentially a 2-year period. And during that 2-year period, there would be regular check-ins between the parties involved with the case. I'm supposed to give a timeline here, but to back up briefly, I will say that TAA, of course, is the plaintiff, the county is the defendant. Early in this process, another lawyer came in, Tom Belanco, to represent interested parties. So during these negotiations and hearings in front of the judge, all 3 parties at that time were involved, as well as some other lawyers, but those are the 3 main parties. The county and TA being principal, the interested parties in some ways secondary, but involved with the negotiations. So during these, I believe it was quarterly, I believe that's correct, check-ins to make sure that we were adhering to the settlement agreement. My understanding, again, and I was not part of the negotiation, is that things were generally on track until, say, June of 2021. So because it was a 2-year settlement agreement to stay until it was going to be heard by the court in August of 2021, June basically represented the last check-in, the last period of negotiation. It was at that time that TAA chose to basically amend their petition or have a supplemental petition that they were going to put forward to the court, saying that they wanted the court to address the issue then in August of 2021, where we as a county would not have any more time in terms of meeting the settlement agreement conditions. So that June meeting basically promulgated the court order that came down at the end of August in, again, 2021, just a couple weeks ago. That court order was one which was a little bit, not unique, but it was interesting in that it was an order that the judge ruled on, but it was going to be an order after ruling, meaning that there was going to be another week of negotiation where some of the details of the order itself could be worked out between the parties. At that point, and again, that's just a couple weeks ago, there was essentially a 4th party that came to be involved with TCAA with representation that also had some involvement in the negotiations of the order language itself. But the fact is that the judge ruled against the county and ruled in favor of TAA. It was just some of the details of how the order was to be written that was in question. So that hearing to basically finalize that order was originally to be held on September 24th of this month. However, TAA had requested that the judge hear it immediately. and again, hear their version of the order that they wanted to be read and ruled on by the court. So the court agreed to do that, and that order has now been entered. The ruling has been made, I should say. So what we're faced with now, just in these past couple weeks, is basically, and again, I'm not a lawyer here, but saying that we were basically stuck with the order as written. And if there's any questions on the timeline, I can entertain those now or later, or I can highlight some of what's actually in the order. So I don't want to work through this thing. It's not overly lengthy, but I do want to just highlight a few of the key components. And that is, the court is ruling that we have to abide by the terms and the spirit of the settlement agreement that the county entered into on August of 2019. So that being the principal framework of that settlement agreement is what we're needing to work with now. And as Dr. Coons has mentioned, one main component of that, of course, is secret compliance for any individual license. Paragraph 7 of the order says that the county essentially shall not approve, issue, extend, renew, or prolong any cannabis license that is not in compliance with CEQA. So that list there, not approving, issuing, extending, renewing, or prolonging, is really what is becoming the definition of the stance of the program or the status of the program at the moment. Paragraph 9 was a point of negotiation between the interested parties in the county and between TAA. The judge was understanding that there should be some allowance for current harvest to take place, that if this order went into immediate effect without the equitable powers of the court overriding that immediate effect of the order, was that people would simply not be able to harvest at all. The judge has decided to side with TAA in terms of their definition of what is allowable in terms of harvest. And they're saying specifically post-harvesting activities such as drying, trimming, packaging, harvest, storage, and sales to properly licensed cannabis businesses is allowable under this order, but only up to October 31st of this year. That was the stance of TAA, and that is what the judge has ruled on. So again, it's a very brief summary of both how we got to where we are in terms of this particular case and the order language itself.
Okay, and I will be just giving a brief update on the program, what's been done, what we're working on. Of course, the work on the transition plan continues. We're working to streamline that document. I'm hoping for an October 5th date to have this item in front of the board. If that's going to be a final draft or a final, it's really getting close to that deadline to get that completed. So one way or another, you're going to see some form of the transition plan in front of you on October 5th. As CAO Coons mentioned, we do have LACO and Helix on board. The focus for those two consultants right now will be focusing on the 307. There's actually a few less because some have site-specific CEQAs. The 300 plus licenses that were issued urgency ordinance extension letters and are in good standing. Those files have been reviewed. We know they're complete. So the focus is going to be on CEQA for those, rather than the file management and application review process. So that will give us a better idea of where we stand with the processing of the Appendix C environmental checklist documents and help us work on creating the process. We're meeting with consultants later this week to start to establish a process of review. And so they'll be moving really quick for those first wave of Appendix C documents to be submitted next week.
So lots going on there. The Cannabis website has been completely revised and updated. It has the most recent information. We've also been issuing weekly memos on Sunday. Draft a memo and we have them posted on Monday mornings just with updates with the programs to keep everybody on the same page regarding what's happening, because it's all happening very quickly. I think that is, it's something. We do hope to also initiate our social media, Facebook and Instagram accounts by the end of the week to also have another tool to reach people when deadlines or urgent information comes up, not just be for the cannabis program. Let's see, where are we? With numbers, again, you've heard the 307 quite often. There's also about 105 pending applications. Most of those are from 2019-20. Many of those were about ready to issue or ready to issue end of 20 or later in 2020, around August, September, and that's when we just started having to hold back on issuing licenses due to the TAA settlement agreement and questions about provisional license issuance. So those, many of those are very close and ready to go as well, and they'll be in the second batch after the 307. So I'm kind of delving into some of the transition plan material here. The transition plan is supposed to be that guidebook on how we process the prioritization, the path through this Appendix C labyrinth, I guess you could say. So it's definitely going to be a document process. Even we do have a final copy in front of you. There may be things that come up and it may need to be amended because this is new territory and we're trying to cover as much as we can very quickly. The staff, we have a good staff on board. We still need more, but right now the focus is on the transition plan. And so recruitments have been ceased temporarily. I hope to move forward with getting those back online and getting folks in for interviews so we can hire. It's just there's so much going on right now. We just held off on any further interviews or recruitments. And with that, am I missing anything? Yes, it's right here. Thank you. We are also working very closely with the Department of Cannabis Control. We did post the memo that they issued and sent to all state licensees through their program, but we also posted the DCC memo on the website. We receive weekly updates from them, spreadsheets that list the active licenses and pending applications and those that need local authorization or where they are, the status of those licenses, those license applications. So they're keeping us informed. We're communicating with several members of their staff and have a good communication and are working together to get through this rough spot. And I think that's it now. Yes, anything to add?
If I could add to that, please. Yes, the DCC letter, Department of Cannabis Control, it was, I would say, a good effort by Derek Cole to be speaking with their counsel and keeping them apprised of the court ruling or the status of the case. So through, I believe, some amount of time, he was working with them to assure that our county licensees who have state licenses, they wouldn't be just losing their county license and their state. They can maintain their state license and be legally allowed to do that. So it represented some good effort and to position those licenses where they can continue through the future. So it does not, I guess one way to put it, in any way really affect the court ruling or the court order. It just basically assures that as the county is working through its process, the state licenses remain in effect so that a licensee, any individual licensee in this county doesn't have to then go back through the process of applying to the state. They basically maintain or retain that current license status that they have. So in that regard, it is one upshot in terms of the outcome of this ruling.
And that concludes our staff report.
Any questions from the board?
want to go first, Dan?
Go ahead. You already got your question.
So, I'm not sure who to direct this to. We had negotiated in discussions TAA not to bring this to court until after the first of the year, and then all of a sudden we're going to court to get this ruling on August 24th. Why was that after we had an agreement? You know?
So for my part, I will say that I was not part of those negotiations in my current position. I'm not sure if you were there, Kim. So I can't answer that specifically. I have been in conference with a number of people, true, but I can't answer that specifically in terms of their decision or why they pushed that forward. I will say that Derek Cole is online as a last resort if you need, but perhaps CEO Coons can answer.
From my understanding, we had a third party that was going to challenge the extension of the contract.
So the third party forced this issue to move forward, even though we had an agreement to wait.
Yes, I wouldn't say forced. So what happened was there's an agreement between TAA and the county, which was publicly presented in court. At that time, a third party said that they would challenge it. And my understanding, again, I was not there, but I know it was a public hearing, was that TAA then withdrew their, based on the fact that it was challenged.
Okay. In this agreement, it said all cannabis. Is that is banned, or are we just referring to you referred to it as all cannabis, but it is just cannabis cultivation? Is that correct?
No, it's all licensure that is allowed under our current ordinance. So that includes everything that's in the original ordinance.
Okay. But every other, except for maybe transportation, would have a CUP, and so they would already be good? I guess I'll look to Kim for that.
In some cases, the non-cultivation cannabis uses will require a director's use permit or a CUP. There's a few that also are a director's use permit. Both are subject to notification and to CEQA. They're considered discretionary actions.
But any ones that we have today have already gone through that process and they won't have to stop business?
In most cases, they were issued categorical exemptions.
Okay.
But their determination was made, yes.
Okay. And what about the transportation license or the indirect sales? I forget the name of the
Non-storefront retail.
Yeah. Those have to cease because there's no, or did you issue categorical exemptions on those?
You know, I have not issued. I've issued one of those, and it was not a discretionary action, so I will need to get back to you on that.
So we only have one of those issued for the whole county?
One of that I have issued. There were some that were previously issued.
So yes. That's a thing that we'll have to look into.
Definitely.
To issue those, or otherwise they'll have to cease operations by this.
Point of order, Kim's memo said C's have to do CEQA
Not a point of order.
Jake, after all these years, we tried to teach you at that point.
Boy, you want to start after all these years? You want me to hold a mirror up? After all these years, we got 4 licenses in the county. Up 50% of the cannabis program.
Please wait.
Oh, get on waiting. We waited for 5 years. Somebody grow some balls up.
Public comment will come. Please
Amazing.
wait.
Call the sheriff.
So,
Go ahead, Ian.
okay. So the explain to me the law that the judge basically made his finding on. I guess counselor, either one. So my understanding is it wasn't just the agreement that he found his finding for the CEQA, that under state law, even without the agreement, that we would have to comply with CEQA. Derek, you want to tackle that one?
Yes, do I need to raise my hand or can you hear me?
I can hear you.
Okay, and I apologize, I didn't put my my shirt and tie back on. But no, the judge ruled very clearly on CEQA grounds. And the judge has made clear that the county is required to conduct a CEQA review every time there is a license issuance, and that has been the case. It looks like you're finally able to see me. So the judge made clear that it was CEQA that the county was violating by not issuing licenses. Yes, we had a settlement agreement, but that settlement agreement simply confirmed that we would follow the law. So it wasn't technically, yes, there was a violation of the settlement agreement, but what really was being violated is that we were issuing licenses without any CEQA review at the site-specific level. And that was the reason for the judge's ruling. And so, it's CEQA. We have always been under an obligation to follow CEQA ever since we've been issuing licenses. And that was the judge's ruling.
And so the state doesn't have to do that because they have an exemption?
So the state has language that is very carefully written. People have spoken about provisional licenses. There have been various iterations of the trailer bill. Prior to this year, the trailer bill said that, quote unquote, the licensing authorities may issue provisional licenses. And when you would go into the code section, these are in the Business and Professions Code, licensing authorities would be defined as CDFA and the other agencies that previously issued cannabis licenses at the state level. Now we have DCC, so we just have the Department of Cannabis Control, and if you go into the current trailer bill, I believe it's in the Business and Professions Code 26050 and the sections that follow after that, it says the department may issue provisional licenses in its sole discretion. And it's very clear that only the department may issue provisional licenses, and if you look up the definition of department in the Business and Professions Code, it is referred to as the Department of Cannabis Control. So there has never been in state law any language that says local agencies, such as counties and cities, may issue provisional licenses. I know there have been folks who have thought that may exist, and I understand that there's been a lot of misinformation about that, but state law has never allowed local agencies to issue provisional licenses. It has always been the state licensing agencies and now the Department of Cannabis Control. And the problem then is that we go under CEQA's definition of project. Every time, and those of us who have been practicing CEQA for as long as we have, the word project is ingrained in our conscious, because that's, CEQA is very clear that whenever there is a quote-unquote project, there has to be some level of CEQA review, even if it's an exemption. And so a license issuance for a cannabis license is a project under CEQA, under the guidelines, under the CEQA statute, and there's nothing that exempts the local licensing from CEQA. And again, the only thing at the state level is because they have carefully written language that allows the state to issue provisional licenses.
Okay. I'll hold my rest. Go ahead, Dan.
Okay.
Sorry to run the show, Jeremy.
You kind of took some of my main questions, so I'll wait.
Well, hit them again.
It's all right. I'm sure I'll have all this up later.
Can you guys hear me?
Yeah.
Regarding the sites, with all of the sites and everything, and Richard, you can verify, the consultants, have they agreed to do the site-specific reviews and inspections?
They'll be doing the Appendix C reviews once our staff does a quick vetting, just to make sure the application is complete of all the items that are required. that they will not be doing inspections at this point. We do have our code compliance staff, and if there's inspections needed, our code compliance staff will complete those inspections. They'll be, the consultants will be working remotely.
Good, thank you.
So Kim, to follow up on that, if Richard says they can do the 307 in a timely manner, do you have the ability to inspect 307 in a timely manner?
Many of the 307 have been inspected within the last year. To get out there and get mattering on, if it matters where they are in their inspection cycle, we're going to try. We can also hire an additional compliance specialist to get on board and get up to speed. But yeah, for 2 compliance specialists, that's quite a few to do, and that would be during the winter when it might be very difficult to get a hold of people or get out to certain sites as well.
And the LACO has the ability to do from A to Z. So if we do need to bring them in for additional beyond just the appendix C, they have the staff to do that too. So in some areas, they do it all. They go to planning commission, they do CUPs, they do everything. So, yeah, so they are available if we have to change a contract to bring them in to do that type of work too. So that was what we were excited when they came aboard, because they're someone that I think, the organization I think will stay on long term, because eventually we will probably have them in county working through the, once we get through these and we're getting a new license. But so there is a possibility of that too.
If I could add to that, if we're going through that, everyone can join in. Yeah, to me, it's very important that the county has a chance to validate or confirm what is going on with any particular license, especially in relation to CEQA. But in my mind, I see it in terms of the Appendix C and the documentation that goes into that is what we're asking initially to be reviewed by these consultants. The outcome of that is that we essentially have a consistency determination or determination of compliance. It's the idea that we acknowledge and agree that this operation is abiding by CEQA rules. That doesn't mean they have a license in hand right then. That is what clears the way for them to be issued a license. So even if at that point of issuing the license, there would need to be a specific site inspection that would become part of that licensing component, but is not always there. I think we need more capacity, absolutely, but there is just some details to this process.
So how do you know they're being accurate in Appendix C if you don't go out on every site?
A couple of steps. One is the initial vetting of the application, which is going essentially through this office in terms of the details and file that we already have, as Director Hunter had mentioned, previous inspections, and to understand, the current condition, at least at that time of last inspection. That is one way to vet them. There's other methods for, if you're, in my opinion anyway, if you're going through an Appendix C and you're working with the product that, say, a third-party consultant had put together, you can understand if that consultant had been out on site, and actually it's another way to vet the information that's coming to you. So there's several checks and balances, I think, that still need to be worked out in the details of this, but the intent is to verify that the information that we're receiving is accurate based on whatever the subject matter might be, whether that's some wildlife species or if it's some project description. The intent is to assure that we're making the right determination.
So you talked about getting, extra help, that you're on hold on hiring. Is there a plan to get that going sooner? Or are you getting more help to get more people in the chairs?
Yes, we'll be reopening those recruitments as soon as we can.
And they've been open for quite a while. The issue we're having isn't putting people in the seat, it's getting people to apply for the applications. I know we're getting a lot of people in the audience that say we should hire. I have a stack of applications, they can come up to the front and pick them up. We are not getting that. We're not getting qualified applicants. That's why we had to go out to consultants, and we may have to expand that and get some more consultants on board. We are not getting qualified applicants. So it's not a matter of pay. We've done our research on pay. We are above Humboldt County in some of our pay, and we're a little bit below Shasta County. So our pay is competitive. We're just not getting the applicants. So we can get the smirks as much as we want, but we're not getting people applying for this position. So that's why we're going out and we're getting consultants. I would like to do everything in-house. I think we have more control, we can have better quality control, but at this point, we are in crisis mode, so we're going to do what we can to get the job done.
And if I could add to that, if I could, the board just took an action earlier today for environmental compliance job description, which was written and intended to allow this department, this division to hire, I believe, an allocation of 2 positions. But that was not actually approved until today. It was involved with the skilled trades and other union negotiations. So at least the action that the board took today helps green light the chance to actually fly for that particular position in this department.
So, I mean, obviously we're at a monstrous crossroads here, and you're looking for direction from the board. And so the 3 options that I see that the county can do at this point is either we ban cannabis, we turn it over to the state and just walk away from it, or we stay the course and try to hammer this out. Any comments from staff on any of those options?
Yes, I'd like to start off speaking on that.
Good people.
The turning over to the state, you start with that one. That option would lead to basically the revocation of our cannabis program ordinances. The cultivation ordinance contains the cap of 530 licenses. The cultivation ordinance, section 17.43, also contains the provisions for what we've referred to as the opt-outs, or areas where cannabis cultivation is prohibited. So those cannabis ordinances, including the cultivation and the other ordinances, would be rescinded, essentially, would no longer be in effect if we handed the program over to the state. What would apply in code would be our land use authority. For instance, in R1 zoning, agriculture uses are not allowed. So it's going to be very limited. So as far as our policing power as the county, most of that policing power relating to cultivation or cannabis activities is in the cannabis ordinances. So that's a big one right there. There's others, but I will touch on that aspect if the program was turned over to the state.
Any other comments?
I'm going to make a comment from a legal perspective, and from a legal perspective, all of those 3 options would be illegal and appropriate.
Would be legally
It
appropriate.
would be legal and appropriate, yes.
From a financial standpoint, I've looked at this as if it could happen. Financially, we're going to lose our licensing fees, but it would stand to reason we're going to have significantly more state licensees, which then would be on the tax roll base, so the general fund would end up receiving the lion's share of the cannabis program. It would affect, in turn, we wouldn't have a code enforcement because we're using cannabis fee dollars to pay for code enforcement. But with the influx in revenues from the general fund, that again could be offset. I don't know what it would look like if we would have 500 or if we have 5,000. I don't know what the state would allow in Trinity County, so I'll pick a number. I think it would increase up to 700 with that. It would stand to reason that there would be some increase in revenues from taxation, and would that mean we'd have larger, more 1 acres than we do right now? Because right now we only have 15. A large acre stand to reason, 1 acre stand to reason to be more revenue. So financially, I don't have an answer for that, but I don't necessarily see it as a financial ruin to the county. It could actually, again, I'm always optimistic. I'll turn lemonade into anything. But it could possibly increase. It definitely would increase our tax revenue, but it would decrease our fees. Now, would that be a wash, or would it be plus or minus on each side? That I don't have an answer for, but financially, the county was fine.
And I do have a follow-up question on that. When you say it would do it with our fees, along with those fees, are you talking about the general plan update fees?
That would be, yeah, that would be, because part of the licensing is $1,000 for general plan. So immediately, we would probably put the general plan on hold, because we're out about $1 million to complete the general plan. So I wouldn't feel comfortable putting the county in $1 million debt until I can see what the revenues would come in from the other side. But for a short time, yes, it probably would suspend the general plan. And there's still aspects we can work on it, which would be of the general plan. Would you say that?
We would hope to continue working on the zoning update.
On the zoning, but there would be other aspects that would probably have to be suspended for a short time.
If I could add to that too, and perhaps I need some clarification in terms of the direction that you're talking about going for this, what now option 1 of the state. So for the CEQA component, if basically the ordinance were to be revoked or dissolved, our county ordinances, then that would require a CEQA action. There would actually have to be a CEQA document that actually described that, and I would have to explore a little bit more of what that exactly would look like, to what extent of a CEQA document would need to be, or if it could be a supplement to the existing EIR. But the point is that it would have an impact on the landscape, basically, anytime you change your land use law in that sort of way. So that would be a discussion that could force us to enter into the CEQA realm, the realm of the CEQA at the program level all over again. If you're talking essentially about handing over to the state in terms of allowing them to be doing the CEQA compliance, they're talking to DCC. You know, they haven't really done that when there's an existing environmental document at the county or program level already. They do CEQA for some jurisdictions, and one example was during some tribal land where there wasn't really any local authorization or local agency that was really in the position to be issuing licenses. They could step in and do it for them. They have done that on a very limited basis. There are, I think, 1 or 2 counties where they do step in and help with CEQA compliance, but it's not at the scale that we're talking about here. And anytime you hand a program over to the state, it's just important to note how quickly that they can move on it. And it is not quick. In my discussions or my understanding of when counties do that for different reasons is all their responsibilities, basically. Analogy is in SMARA, if the Division of Mineral Resources were to take over the county responsibility as a lead agency, that can increase the fees quite a bit, and it to the license holder or the applicant, and it can increase the amount of time that it takes in order to actually comply with, in that case, smaller regulations. So I can see a parallel here where if we were to dissolve the program and try to use the existing DCC programmatic EIR, or they would be using it, it could be a lengthy process because that specific programmatic EIR really only has 2 mitigations that it calls out, if I recall correctly. What it does do is basically every section of that EIR points out that you have to have local verification and local studies to support any determination of an appropriate mitigation. So it's a big document, but it doesn't say a lot. It says, look on the ground and see what you see. So that process alone is basically where we are already with our own individual licensees in our own existing program. So there's a lot of talking there, but just in terms of the CEQA side, there's some nuance in terms of how you would structure that in terms of program revocation or program suspension in lieu of the state taking charge.
In short, he lives
In the end,
Excuse me, public comment does not count, and if you cannot remain quiet during the board's discussion, we will ask you to listen from the lobby.
Amazing.
I was going to say we recommend we take a 5-minute break.
Okay.
Clear the room while we're doing so.
Let's call the private session.
No, everyone's clear, clear the rest for a second. Thank you.
That's not legal.
Of course it is.
And you're the reason that we're in this position, is your bad legal advice. And you just asked the guy who's gonna lose his job what he thought about doing away with the
He's
program.
making decisions for my best
Thank
interest,
you.
and I'm paying him.
You don't have the cannabis programs.
Those aren't my best
Seriously.
interests, bud. Sorry.
The only person who makes more money out of this is probably
I don't think
you.
you should get paid anymore for my cannabis money.
Honestly.
I seriously think this is over. That's not okay. He's not
We need to
representing
clear the
me.
room. This is
You
the
guys
most
have allowed
public
somebody
meeting.
to not represent me for my
Honestly.
financial best interests here. That's the bottom
Seriously.
line. 100%. I didn't approve this, and we need to have this discussion. That was absolutely horrible discussion right there. What he made was not the correct decision.
He should have just sat there and said, well, I'll lose my
It's
job.
not. That is not the correct decision. Sorry, bud, you work for us.
No, this has been 5 years of this bullshit.
Sorry.
This is fucking insane. You can't close the room in a public meeting.
Not close the room, I'm asking to clear the room.
You just said that.
I said clear the room. I said we're taking a 5-minute break, we're gonna clear the room. Thank you.
You can have a 5-minute break.
Please clear the room while we're doing so, we're gonna lock it.
You're gonna lock the room, and you're all gonna have a private conversation.
We're all clearing the room. Clearing the room. Thank you.
So you're not gonna have a private conversation after you leave.
No, do you want to?
You are, 100%.
We're gonna have to shut this meeting, do it another day if you don't cooperate.
Amazing.
Work.
What's another day?
Walk out, please.
What?
We're gonna have to do it another day.
All right, Jake. That's insane.
Get your way.
You guys are fucking crazy. Jesus Christ.
Can't have that stuff.
They said they're gonna postpone the meeting.
Yeah, what I've learned.
Continuing on.
Give it a shot.
I don't sell nothing through the county. I sell it.
Want me to say that?
What this county does is irrelevant at this point. You do not do that.
You were wrong. Truly.
Come back in 5 minutes. Not yet.
Jeremy, I don't know if you can see, but we are coming back.
Just 1 second. I was going to give until 3:05. Sorry.
Then I'll let you announce it.
Okay.
Oh.
I think you're fine, just so you know that camera's going to go play.
Okay.
I got it.
Okay, Jeremy, are you still on?
Yep, I'm still here.
Perfect.
Chair Commander. Okay, so we're gonna try this again. For Brown Act, we can stop, pause the meeting, clear the room, and then come back in. However, per Brown Act, if we stop again, then we have to close it to only media, and then if we stop it a third time, we have to read. So I'm optimistic that we're gonna be able to all stay in the room, take comment, and see where it goes from there. So thank you, everybody.
All right. Were there pending questions from the board? This is the board's chance to ask questions.
Yeah. So I kind of lost my train of thought also, but of the three options that are on the table, state, no grow, and we're right now with full secret compliance. Option B and C for me are just not even thought. I don't think we want to see this county as a state-run county. The state has done nothing for us so far as a county, and obviously no grow is just going to be the craziest thing we've all seen. So I'd like to see us stay the course. We worked hard to get some consultants in here. We're going to get more people. As David said today, we just gave agreement to get 2 more people in. We do have commitment from both of the consultants to get 300. Secret compliance is done by the end of the year, and they will work, and I think it was Lako, which is not correct, said that they will work with farmers on the ground.
If need be, that's not their assignment right now, but they have the capacity to do so.
So they have that capacity, need be. We have that to fall back on also. So at this time, I would never introduce B or C as an option for us. I think we come far.
Just focus on the questions for now.
Okay.
And
was there a question?
If I may,
Questions established.
I would like to ask the board if they would entertain Supervisor Grove and Supervisor Frazier being part of a short-term cannabis ad hoc committee, and if that would be of value in the eyes of the rest of the board. Keith, you've been there before, and Supervisor Frazier spent a lot of time on the commission. I think if that's something you guys would be interested in doing, with the purpose of just having more interaction as supervisors with the process. If you think that is of value, that is something I would be supportive of.
You want to address that?
Yeah, I think one of the problems last time, which I think we were extremely effective and we wouldn't be where we are today if that hadn't happened. But I think if the board came up with a clear and concise role of what you wanted us to do and bounds and the boundaries that you want that to go in, I of course would be more than happy to serve on that. I have said for a while that there needs to be oversight. Not oversight's the wrong term, but I think more participation in this than we've had. And since we disbanded the ad hoc, basically we've just kind of floundered for 2 years now, I guess. So I would be more than willing to serve. Also, I would support if Jeremy, you chose other people, I would support it for anybody on the board.
Thank you for your consideration.
I would be willing to serve on an ad hoc. At this time, my question would be whether or not it would really make any difference in this process, or whether by the time we got squared away as an ad hoc committee, if we could have this done. I don't want to spend time reviewing when we need to be moving forward, if that makes any sense. I think we need to, I do think that there needs to be some investigation into how to move forward, that kind of thing, but I don't really see the need for an ad hoc addressing this particular issue. I think but if the rest of the board sees it otherwise, I would be more than willing to participate.
Yeah, Dan, what I would say is that my experience in the past is staff doesn't always ask for what they need, and they try to work along and to have oversight or weekly meetings or whatever it is. And I don't mean to degrade staff, they're trying to do what they do. And if you're actually in the trenches and you hear the problems that day, then we're not part of the minutia. We can sit back and say, wait a minute, here's a real blank that we're missing, and I know you're going to get to it. So, but if staff, I don't want to be in a situation where staff doesn't want us or anything like that. So I do see the value of it. But again, I serve at the pleasure of the people of Trinity and other board members.
So I guess I would like to throw this question out to staff. What do you think? Both of you.
I think maybe it's better to ask the CAO than to put staff on the hot seat for that question.
Richard, you're on the hot seat.
I agree with Supervisor Fraser on this particular situation. We really, again, and it depends on the direction given from the board. If direction the board is to get everybody licensed up, then we know our marching orders, and that's what we're doing. That's what we're starting with the consultants. If it is to change and leave the program we're under, then absolutely, I think some type of ad hoc, because we're switching direction. We're going a new direction, which is going to have new ordinances and new rules and a whole bunch of new. So it really depends on the end of the day what direction the board gives us. So I do think on down the line there could be a place to help write additional ordinances, because we have new ordinances coming out. We'll have stacking and retail and different things like that. And ad hoc was very effective in doing that. For this particular situation, it really depends on the outcome of this meeting.
And that's kind of where I was going with that too. I'm open in the future, but
If you wouldn't mind just briefly, I concur wholeheartedly what the CAO said. The ad hoc served an essential purpose in the drafting of the ordinances, and because staff doesn't have time to do that, because they're trying to now carry out the purpose of the board's pleasure. So I think if you're looking at doing an ad hoc, I would divide it up by having them look at revisions to the ordinances, which we all know need to come, and the creation of new ones that have been put on the back burner since the ad hoc was suspended.
Okay, I appreciate you guys entertaining the concept, and it sounds like holding for now and maybe solidifying future issues that an ad hoc would look at would be more appropriate. Liam, were there questions you had of the presentation in general?
No, I think I'm good. I agree with Richard that I just don't want anything to get in the way of us moving forward in the direction that we are right now. And there will be things in the future we'll probably need a little bit of manpower committee for, so that would be my vote also.
Supervisor Frazier, do you have any questions on the presentation and the item?
Oh, I was trying to figure out how to state it or make a question. We did go through what it would look like kind of from the county's perspective, staff perspective of what would happen if we turned it over to the state. And since we've done that, I think it's fair to go through what it would look like if we banned cannabis. What staff's thoughts would be on the effect that would have, and again, what we have to do CEQA-wise for that, and get that out in the open too.
I'll just jump in real quick. I do not support that idea, and there's other counties that have tried that. Calaveras is one of them, and they lost a $16 million lawsuit, and they're $9 million in the red, and still trying to come out of that, and in the end, they were instituted a cannabis program. So, from my point of view, I don't see anything positive out of that. So I'll just leave it with that.
I would say yes, CEQA would be required and concur with CAO Coons.
So we would have to do an entire new CEQA document to do away with the program.
Yes.
If we decided we were going to go no.
Yes, there's case law on that.
Okay.
And I would agree with that. You would have to do CEQA when you're disbanding the program. But if you do it correctly, it can be disbanded.
Okay.
I have one last question. Since we are going to be in flux here, and CAO, you stated if we went to state only, you would put the general plan on hold. But do you still recommend that we go forward with the general plan with our program up in the air? Or do we put it on hold until we get it on solid ground?
Well, since it's based on licensing fees, we haven't expended the money we have yet, so we continue that point. But if we started tickling past that 1.6, 1.5, 1.6, I don't want to see where we are in the process of issuing license. So that's something I would take a good hard look at, because again, I don't want to put the county $1 million into debt with no revenues anticipated coming down the line. But at this point, we haven't expended what we have, so I wouldn't. But if we got close to that and we were still not able to issue license, and that's a decision I make then, and that'd probably be the answer to yes. We'd have to postpone it.
Okay. Thank you. I think that wears out my questions for now.
Are there any further questions from the board?
None from me.
Based on one other consideration, I'm not sure if it goes to Richard or Margaret who speaks to us, but how does enforcement or a sheriff, are they affected by any of these decisions?
Let me see if I can clarify the question. So how would code enforcement be affected by the three different decisions, the three different ideas? Well, obviously, if we disband the program, then there's no reason for enforcement as far as code enforcement. It would just be whatever, we'd have those lost revenues, and the sheriff would go primarily to just criminal as opposed to any type of civil. If we moved it to the state, again, as I said, I anticipate that there would be an increase in the tax revenues. So we could see an increase in funding. We would transfer from code enforcement to probably just cannabis enforcement, and then I don't know if it would still be civil or it'd still be criminal. But the sheriff's department would be affected with those two. With the third of getting our program back on feet and running it, then we'd stay the course with our code enforcement.
Thank you. Unless there's any further questions from the board, I guess we take public comment on this item.
Is there any public comment from within the room?
Terry Mines, Junction C. Last time I checked, supervisor was supposed to help us get to work, provide jobs. Remember Carl Fisher always saying, jobs, jobs, jobs. I said, Carl, give us a license, we'll have a job. 5 years later, I think he was a smart guy. But this is, Keith, you asked an excellent point, the state. I think it's time. I think we've seen enough corruption and unethical behavior in this county. It's time to get it out of the county's hands. I think that's just really the honest truth. It goes away from Judge Letton being the hard money lender, brother. This is ugly, okay? That's very true. You heard my tapes earlier. Kim's never had an honest day in her chance to even run this program without Leslie's hands tying her up, helping out TAA. We got the facts, we got the tapes. So there's no more lying on this, okay? You guys won't give me my emails? I'll get them, don't worry. The county's gonna see them all because that's how I operate. But it's time to let the state take over here. David tried to scare you. This was all fear tactics, protecting jobs. That's not true. The state does this with other counties. It's not gonna hurt anybody. We're all going to sequel. The problem is that us license holders were the ones that were always attacked here, Keith, not the illegal farms. Code enforcement kept screwing with us. They shouldn't be involved in this anymore. They don't have the capability. Barcelona makes a mistake every year, at least once or twice. Puts the county in serious liability. I think Richard's explained the liabilities here. I don't know how many lawsuits are going down. We know we have a Judge Boatman that's in place, and the real ruling wasn't read exactly how it was. David didn't read it exactly. The judge's ruling was ruled like ridiculous, okay? And that is unheard of. I know that from talking to other attorneys, that never happens. The judge never gets embarrassed like that or anything. So really who we should be talking to is Derek, I think, again, because Derek's the one that actually knows CEQA and he's the expert. And I think Derek would have been the right person to talk to, not David, about the state and the state taking over. Just to be honest, I think that he was the one that has the knowledge. I think he's the one that, I don't think Derek ever had the honest truth too, because he's getting in front of a judge that's friends with Judge Letton. Okay, so what's going on? The state pretty much said that this ruling was ridiculous. Okay, I think there was agreements made, but last time I checked, the lawsuit was dismissed originally. Okay, only when Judge Letton took over as the lawyer did it get reinstated. Well, I proved with that tape earlier that, and I have a tape showing that the judge is still making the calls for TAA. He's still the president and the lawyer. And they also lost their charter for a few months without paying their charter correctly, however that works. So I don't know why our county is not suing TAA for a frivolous lawsuit. I'm doing all of this and handing this over to the state, seriously. Going after Leslie Hubbard because she's going to collect money in pensions, and we know that she helped TAA undermine a county ordinance. It sounded to me like they were conspiring to undermine a county ordinance. I'd like to talk to the district attorney about it. That's what I think. I think they're the criminals.
So is there public comment?
Jay Grossman, Chris Hayfork, Big Common Collective. For everybody, I'd like to state that nobody in this room has addressed that we no longer have a program today because of the advice of county council. And I don't just mean Margaret, I I mean, the entire firm that we pay, I think, like $600,000 a year to advise you guys on what we do. You guys are all ordinary citizens. Some of you have sat through multi-generations of this stuff. Some have sat through thousands of hours. Some are new to the board. You guys are looking for honest, correct legal advice, and I think that right now we have seen from a judge that the advice that you guys have been getting for 5 years now, which sadly encompasses our living, is grossly wrong. I also don't agree with the judge or TAA, but here we sit. A couple things to touch on. We've been talking about what happens if the program goes away, code enforcement, this, that, and the other. I think it's ironic that county council called the sheriff's office and they sent down the sheriff that illegally raided our property, my family's property, and was thrown out in court and pointed guns at my children. And now you guys sent him down to try to intimidate me to not speaking or something. Come on, that's incredible. You know, there's only a couple licenses that are active right now in the county. Can't even get our renewal for our CUP issued because Kim is hung up on somehow with our road use agreement with Forest Service, even though we're at the dead end of a Forest Service road, somehow she thinks we need a county encroachment permit. Legal team can't figure it out. There's so many issues to address. 2 minutes isn't going to do it. We're asking for advice on if this program should go to the state or not from the people who are going to lose their jobs if this program goes to the state. You're not asking the farmers who have been in this for 5 or 6 years. I have 13 pending licenses that all have CEQA done, that all are just sitting there on existing gardens, just sitting there. Gotta hit print, there's tax dollars. There's tax dollars with no more CEQA review. We're talking about hiring on more people. If I had $100 for every time I have sat in this room and heard say, we're bringing on more staff, we're gonna plow through this, it's a staffing issue, I probably would have more money than I have from growing pot. I mean, we need to take a step back, look at the reality, and try to move forward, not sit in this made-up world that goes on here, but let's step outside. Let's go to Hayfork. Let's talk to the farmers. Let's have a roundtable meeting instead of a couple hours of just made-up conversation having to do with this, where then we
Your time is
come
up.
to some, I can see thanks. Until we come to some.
Please stop, your time is up.
Okay, and you too. Your time is definitely up.
Any other public comment from the boardroom?
Thank you.
Good afternoon, Lisa Wright.
One second.
I don't think I'm, there I am. Lisa Wright from Lewiston. I'm going to skip around a little bit because we touched on a lot of things. I would support a continued county program as allowed in SB 94, which is a one-time land use permit along with an annual business license renewal. We could easily do it through the Ag Commissioner when we go to certified scales. One-time land use permit. I oppose funding 100% of code enforcement through the cannabis dollars. I think that's illegal. I think it needs to stop. At a minimum, in good conscience, you should at least reimburse the cannabis fund for what you used it for to collect. One of the things that came out recently, I think it's absolutely excellent. Thank you so much for the weekly updates. I think all people have really wanted all along is just clarity and transparency. We didn't have that with the ad hoc before. I'm sorry, Keith, I'm opposed to doing that or to having people who don't have or don't support farms in their district being a part of that moving forward. I think the grand jury actually commented negatively on the ad hoc as well as somehow subverting some of the Brown Act requirements. But back to the memo weekly, very good. The updated website, excellent. I do have some questions about asking too much of the farmers too quickly. You're talking about, we have a consulting company that can review 300 some CEQA documents. Well, the farmers were told even by staff this year, you don't have to do biologicals yet, wait on the transition plan, wait. And now you're saying, okay, now we have people, now submit these instantly. It's not gonna happen. CEQA documents are complex and they take a while. So be conscious of that, please, when you're saying we have these consultants that can suddenly review CEQA documents that are gonna materialize 300 of them. I don't think that's being very realistic. Also going back through staff for questions that the consultants will have of the farmers, that could potentially be a bottleneck. You're saying you don't have staff at this time, so maybe consider allowing the consultants to go through the consulting firm if there is one. We don't want a bottleneck in Kim's email like we typically have with non-responsiveness. Renewals, I'm a little bit confused on the memo about the renewals. It's really not clear. I have a license I renewed in April. I got 5 months worth of license. Where's the rest of my 7 months? I want some kind of credit or reimbursement. And then when do I have to renew? That's all like a big question mark. And now suddenly we're going to take 300 CEQA documents and start reviewing them. And no clarity, no timeline in terms of how this is going to proceed, besides what we learned today about suddenly we can do 300. Let's see. Yeah, I think that about covers it. So thank you for your time and have a great day.
Any additional public comment from the board member?
Good afternoon, Teacher Brower. Well, I'm really happy to see some progress. We've all asked for a long time. So I'm really pleased that 2 firms have been contracted with to review these appendices. I agree with Lisa that it's going to be tough to get everything done by the end of the year. There was not really clear communication and what needed to be done, and not everyone has the biological assessments or other needed components of it. So I would be concerned if we were only contracting through the end of the year. What are we going to do with the people that are going to be done early in 2022? I have spoken with many members of the state and different agencies, and they're not going to take on as lead agency for us. So even if we went to state, we would be stuck in this CEQA conundrum, which they require faster, and the county requires it faster than the state does, but we would still be in a bad spot there. I also agree with Lisa for having a one-time land use permit and not going through the same forms every year when things aren't changing. Once they've been allowed to cultivate on that parcel, some of the requirements should go away. And what else? Oh, and the memos and the more information on the website have been nice also. Thank you.
I'm running the clock for the whole time. Thank you. Tom Malenko, Douglas City. Good afternoon, Mr. Chair, wherever you are, members of the board. Let's see, a couple of things. As regards to transition, as I understand, the plan is to have people who were previously issued a categorical exemption have to redo Appendix C. I can understand why that is the case, but that will cause an awkward situation with CDF, well, DCC at this point, because at least a number, and I can't tell you how many, but I know some of those licensees who were granted a CE previously provided that to the state authority and were upgraded from provisional licenses to annual licenses based on having complete CEQA at the local level. I don't know what that would look like in the case where, let's say, somebody who had a CE and for whatever reason has a problem with our CEQA now, what that would look like with the state. So I think that's something that needs a little more looking at. As regards the 3 options, I'd suggest a hybrid as regards state. Let state handle licensing. I think the county, had we had our general plan done 5 years ago, I think we'd be in a much better place to say, let's leave this up to the state because we know what kind of zones are appropriate for cannabis ag. If we did this as really land use and more like a land use entitlement, and maybe in the context of our general plan update created a cannabis ag zone to solve some of these problems, we could have these licensed or potentially licensable parcels go through the county one time, look at its CEQA, is this an appropriate parcel? And then leave the licensing up to the state, so we don't have to do this every year. Now that is something I think an ad hoc would be appropriate to look at that. It allows for a site-specific review, but it doesn't subject it every year, which is a burden for staff, a burden for landowners, and probably stirs up neighborhoods more than it needs to. Finally, as regards TAA, thank you Supervisor Groves for clarifying. I didn't really follow your question last time about accelerating. I wasn't aware that the county and TAA had reached an agreement about delaying anything until the first of the year. Now, my 9 clients, 2 of whom are in this room, would never have allowed me to agree to that anyway. You know, we talk about the spirit of CEQA. If CEQA has a soul, it's notice and comment, both of which are preceded by the word public. So that process belongs in the public, not in the side agreement. So it's unfortunate, but I'm glad we're back in the public. Thank you.
Is there
Any additional comment?
comment from the room? Seeing none, I will move to Zoom. We have Adrian Keys.
Hey, good afternoon. It's Adrian Keys from Hayfork. I'd really like to stand in support with the comments from Lisa and Deidre, primarily. And I would request that before the county even considers any sort of an option where we would, somehow do away with the program and revert to state, you do communicate directly with the state and get it directly from them. I know during the TAA lawsuit, I tried to provide access to the state legal counsel, and I don't believe that it was ever followed up on. We may have been able to avoid a lot of this if we just seek the information out accurately. I also strongly agree with the idea of a one-time land use permit. That's the jurisdiction that our county has. The county does not necessarily issue business licenses for cannabis. The state does that. They're the licensing authority. The county has land use jurisdiction, and I believe that we should stick with that, a zoning clearance, some sort of other permitting process, and it would save endless amounts of time and money. I realize that can't really take effect until we reach our annual license status, because up until that point, we've been operating in the provisional world. I will avoid going into my interpretation and the interpretation that I received from state legal counsel about provisional licenses. I believe I've made that point before. And I'm a little bit aghast that this has turned in this direction today, that there's discussion of either doing away with the program or going to a ban or going to the state. This should be a discussion about how we're moving forward, not how we move backwards. I could go into depth about my opinions on what that would look like on the ground here in Trinity County. I don't think there's any reason to assume that you would see further participation in the program if we went to the state. I think that almost immediately it would in fact go the other direction. People are so tired and frustrated and working so hard to come into compliance and not being given the opportunity that frankly I think that the enforcement budget, I don't believe there would be much in the way of tax revenue. I think that in fact, well, we would lose access to all the state grant funding for enforcement. We'd lose access to the state grant funding for environmental improvements, and there would be absolutely no reason, in my opinion, to assume that we would get even one new farm to come into this. I know one person. I'd like to ask if anybody has heard of the state being lead agency for anyone with an annual license at this point. I know one person, Mono County. He's been in application with the state for 4 years, and they have still not processed his documents. And they, in fact, have never even provided him with a provisional license. He is unoperational for this entire time, 4 years. So I would appreciate looking further into that and just giving it a rest. Thank you.
I have no other hands raised and no other chats. Oh, there we go. Patrick Cahan.
Patrick Cahan.
Sorry about that, can you hear me?
Yes.
So I'm picking my jaw up off the ground at how much I've learned in the last hour plus in this meeting about what's been going on with this program for years in unsealed quarters of the county that I'm not aware of and invited to, and that's just an extreme disappointment. What I'm really gathering is that the program starts on Monday. Wow, I've been looking for that kind of information for a really long time, and I'm excited about that. But I'm also really curious to how it's going to work when I am one of those people who has a CEQA exempt, but now I have a piece of paper. I don't have a license from the county. It's really odd. And on top of that, I know that it's going to take a really long time for people to get through this CEQA process because I've been trying to go through one for 3 years in the county. And so I know what it takes to get an NSO, and I know what it takes to get a biological assessment, and we're outside of the window for the biological assessment, so that's really disappointing, and I really hope you guys can focus on some solutions and following the state's lead a little bit more in step with the state law. And I appreciate you guys for your time, and I really hope you guys will find a good way to move this forward, because I see a lot of transparency in the room that's been missing. And I sure hope we can bring more of that to this program. Thank you.
Ryan Tarbell.
Good afternoon, supervisors. I would also like to echo the comments of some of the last few speakers about how my understanding is the state isn't really equipped to be doing CEQA review on these projects. So I think we really need to move past that and really focus on what's in front of us here, and that's getting people through Appendix C review as quickly as possible. A few comments on the memo that was just released a couple days ago by Director Hunter. I don't really think the review on Appendix C's should start until the transition plan has been released. It's really putting the cart before the horse, and as she even alluded to during her presentation, there's many aspects of Appendix C that are really going to be unclear until we do have a transition plan, and then that's also going to change over time as the hurdles emerge within the plan. I'm also confused by the renewal section on the memo. It's just really not clear. I think Appendix C review should occur by your license number, so the people that have been in the program the longest get reviewed first, because there's a good chance this is gonna take quite a bit longer than anticipated. We can see how slow the CUP processes went, and this is more streamlined, but it is still gonna be a big hurdle to get over. And one final comment, I think it also states in the memo that all communications will have to go through the planning department and back to the consultants doing the review on the Appendix Cs. I do think the process would be streamlined and alleviate some of the load off the planning department if we could communicate directly with the consultants doing the review on the Appendix Cs. Thank you.
John Brower.
Good afternoon, supervisors. The county's in an awkward position, and this is one of those moments we need to see some leadership. The county's come a long way in a very short period of time on all of this cannabis stuff, and at this point, we're more than 50% the way across the river. And it sure makes sense to keep going to the other side. The state has neither the will nor the capacity to act as lead agency. That's crystal clear. There is no going with the state. It's we lose our cannabis program, we'll lose all the environmental benefits of the program, all the community protections of the program, all the enforcement and environmental funding available from the state, and we'll lose a tremendous opportunity. You know, you would, any other broke-ass county in this country would be offering incentives and begging several hundred small business to come relocate to their county. And this is an opportunity. And if we miss it, it'll never come around. The rest of the work out right. I think that's what we need to focus on. So I encourage the supervisors to get even more hands-on with guidance and support of staff as they implement the transition plan. It can be great to see what's in the transition plan and the actual methodology to get to NODs. And it's a big lift, but we're already, done a lot of it, and we're very close to being able to pull this off. So please continue forward on this path. And I think we should not consider dropping the program until after we at least see the transition plan. Keep moving forward as a community. We can do this. Thank you.
I have no other raised hands and no other chats.
All right. Is there any further discussion with the board? It seems like there's no item to specifically approve.
We're supposed to give direction to staff, I think was the intent. So.
It was to discuss and then direction to staff as to
how to move forward.
Yeah, how you'd like the staff to move forward.
I'll go ahead and start. Kevin, the good news is we just have heard a lot of testimonies that the state of California, with 38 million people and $1 trillion budget, can't do this program as well as we can. So congratulations, Ken. Good. You're ahead of the state of California. Yeah, it is.
And David too.
So with the testimony given today, I have no other thought that we follow the recommendation of the CAO, bring on these consultants and start this process and move as fast as we can. There's a lot of asks that got asked today that are out of our control with the court rulings. So that's, we don't have the flexibility to just put things off like we had hoped to do. So with that, my direction is to, my personal direction, just one, is to go ahead with the CAO's plan and Kim's plan and David's plan and move forward, and looking forward to a transition plan on the 5th.
Can I make one clarification? Because we did have some, the consultants are on board. We've signed contract agreement with them, and it's not till the end of the year. They're on board as long as we need them. So it's not just to the December 31st. As long as we can afford them, they're in for the long haul. So I'm anticipating one of them maybe with us for years.
I would, if it was me, and this is just advice, is that I would really prep them for having those personnel to be able to get on the ground and having that infrastructure to hit at a moment's notice. And I'm not intricate in the program, but it sure seems to me that that's something we'll have to utilize at least up front.
You're meeting with them tomorrow? Thursday, okay.
So I agree with Keith. We do need to, I think, put boots on the ground for us, and I think that's going to be an important part. I think the communication between us and Helios and Lakewood is going to be a that's gonna be a hurdle, you know, to get someone in there to keep that whole ball moving. So I would like to know from either yourself or anybody on the staff, if there's any deficiency in it that's holding this thing up, that we're not running as smooth as we should between our county, David, Helix, and Laco. That's where I see kind of the gap there. So I'd like to know if we need to get someone in there and get that done. There's no use going to the lengths that we have gone to and have a little break in our transition. So I think that to complete the circle, if we have a little bit missing from it, we should get somebody in there. I do think that there was great questions asked today. There was really some questions that I know have come up before us before, and it was good to hear in open forum what the public has to think, their interests, and I think some of those will be helpful to us also. I don't believe the state or no-grow is an option for us at all. My direction to staff and Richard would be to continue to hire all we need until we can get through this. It's going to be a while, and I anticipate, as Richard does, to keep probably one of these firms on for a long time, maybe for a real long time. So my recommendation is to stay the path, and we'll keep the county doing what we do.
I think I would have to agree that the best course of action would be to continue to move forward in the way we're headed, and we have been headed for the past couple of years. I think it's, personally, I think it's a little strange that a lawsuit intended to speed up the process has done nothing but slow it down for probably several months. But it would be, I think it would be detrimental to do anything besides just keep doing what we're doing, and as a board to support staff as much as we can to ensure that they can get it done as soon as possible. And my personal direction to staff would be, don't be afraid to reach out and let us know if you need something, so that we can help you along that route.
All right, is staff clear? Direction, are there any other questions for the board from staff?
No questions.
And I believe that the meeting, unless we need to have a formal vote. Is that the case, Margaret?
We do not, staff feels they have a focused direction.
All right. See you guys tomorrow at the budget hearings.
See you.